Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing misconceptions associated with American visas from Thailand. And every now and again, people kind of start saying the same things to me when I'm talking to them about immigration matters. And it leads me to believe that there must be some forum or something out there where they're getting erroneous information. And every now and again, I try to go ahead and compile some of the things I've been hearing and do a video like this. So to be clear, this is misconceptions about American visas from Thailand. So this is visas to the United States from Thailand. One of the big ones, I see this kind of constantly, is people view tourist visa applications, especially for the significant other of an American, as a relatively easy or straightforward process. In point of fact, and I've made a number of videos on this channel regarding this, but Section 214B of the Immigration Nationality Act is a threshold that many in that position are not going to be able to overcome. That's just the plain truth of it. Now, there are circumstances where they may, and it will depend on the facts of a case, but 214B is a high threshold to beat, and it's very likely that most tourist visa applications, again, especially those especially for those who have a relationship with an American, 214B is probably going to knock those cases out of the box every time. With respect to tourist visas, another thing that I see a lot of people talk about is, I do have a Thai girlfriend, I'm trying to get her a tourist visa, and I'm showing that she has property or a job in Thailand and things. It's not really what anybody's looking at. It's the relationship with the American. At the end of the day, 214B calls upon the adjudicating consular officer to go ahead and do what's called a strong ties, weak ties analysis. They have to determine that that applicant has strong ties to their home country, and this is key, weak ties to the United States. Oftentimes, any kind of relationship with an American, especially a romantic one, is going to mitigate or operate against that weak ties side of the analysis, and is probably going to result in denial under 214B of the Immigration Nationality Act. Another misconception out there that I often find interesting is the presumption that getting married is a faster way of getting a significant other in the U.S. In point of fact, it might be, depending on circumstances. It also might not be. So for those who are unmarried, it may be a good idea to go ahead and explore all their immigration options before making a final decision, because the K-1 fiance visa is out there, and under certain processing conditions, that can actually be a faster method of getting into the U.S. Another big one is, this isn't so common now, but when I first came to Thailand and was doing U.S. immigration, it seemed like every fifth person I talked to just thought they could just walk into the embassy and file one piece of paper and go ahead and get a visa to the United States. Now, reasonable people could argue that perhaps that's a better way to do things, but the fact is the immigration system is quite a complicated, in fact, I would dare say Byzantine set of institutions associated with ultimately getting the visa, especially an immigrant spouse visa or a K-1 fiance visa or any type of visa that confers long-term status in the United States, especially work authorization status. You're talking about some time spent and a lot of documentation and a lot of processing. It's not just a matter of walking into the embassy with one significant other and walking out with a visa. And the final one I do see occasionally is the notion that lying or being evasive about possible what are called grounds of inadmissibility is a good way of dealing with immigration. And where we see this oftentimes is in the context of folks that have prior criminal records, and they try to hide that, oftentimes through rather less than optimal methodologies. The other thing we see is folks that have worked in activities that are considered grounds of inadmissibility, even where they don't have a conviction or an arrest record, and they just are wanting to go ahead and lie about that activity. Oftentimes that's going to get you into way more trouble. In fact, the lie will get you into way more trouble than probably the underlying issue that you think is there. And in some cases, it may not even be the issue you think it is. There are certain things that one thinks, oh, I have a criminal record for this, and that's going to keep me from getting a visa. Probably a good idea to contact a legal professional, gain some insight and guidance into how best to proceed with this, because that may, what you think may be a deal killer might not be, depending on the circumstances. So again, probably not a terrible idea to contact a legal professional if you're dealing with any type of U.S. immigration matter, gain some insight and guidance into how best to proceed.